may cleans gently, leaving skin feeling soft. And soft skin is one of the nicest things a woman can own, even on her nose.
Kame cares about soft skin as much as you do.
Jeff is mentally handicapped. He runs every day, giving everything he's got to train for the year-round Special Olympics. You can help Jeff and all the Special Olympians. A $1 contribution will be made every time you send in 2 proofs of purchase from Oxidol, Bounce, Tide, Downy, or Cheer. See details at participating stores. Help someone do something special. Support the Canadian Special Olympics.
BCTV, our best show.
Good morning. There's a good piece of news from Ottawa this morning. Or it's almost a good piece of news. Now let me think of the basic happy facts in Canada today. There are about 1.5 million people effectively unemployed, perhaps 1,700,000. You can't really tell once they seasonally adjust things and do their double shuffles. But the Minister of Employment and Immigration has very graciously told us that they're only going to increase the jobless by immigration by about 8%. They're not going to bring in 144,000 immigrants next year. They're just going to bring in 110,000. Tough luck on the immigrants. I'm not going to quibble too much about the refugees, but I do wish, or I do hope, that when Mr. Axworthy is here on Thursday morning, he will give us some facts and figures on family reunification, which probably in terms of numbers exceeds the amount of official immigrants coming into this country. And it's merely a question of how much hard-pressed social services can afford. I'm very delicate talking about restricting immigration in front of my first guest here this morning, who happens to be Ottawa's Commissioner on Human Rights, Gordon Fairweather. But we'll have a little nag with him about it later on. And then, good news again, nothing but good news this morning. The vacancy rate in rentals in the Vancouver area is now almost up to 2%. Now, it might get a lot bigger than that, but we've got Jimmy Patterson, the Rentalsman, here this morning to answer your questions about all these wonderful new developments in rental accommodation and the law in British Columbia. But first, Ottawa's Commissioner of Human Rights after the break. Gordon Fairweather has been the Federal Human Rights Commissioner now for low on 5 years. And the first thing I want to get from you is your approbation and your enthusiasm, which I'm sure you have, for the magnificent decision by Dermot Owen Flood under the BC human rights legislation saying that Hunky Bill can call himself Hunky Bill and nobody can complain. What do you think of that magnificent common sense decision by this wonderful Dermot Owen Flood Canadian?
Well, I'll deal with Mr. Owen Flood in a minute, but your intro had me as Ottawa's Commissioner for Human Rights. And this is a problem in British Columbia. They equate Ottawa with the country. Ottawa isn't the country, and I'm the Canadian Human Rights Commissioner. And now that we've got that straightened out, I'll talk about this hunky bill.
You're reprimanding me for my built-in sense of alienation in that somebody from Ottawa I don't regard as from Canada, but as from Ottawa.
That's exactly right, and this is a problem, you know, that we face
but you're
in this
Canada's
country.
Human Rights Commissioner,
Yeah.
I'll concede that. Please accept my humble apologies.
Thank you. A concession from you, Jack Webster. We're starting out on a good
Please
note.
accept them again.
I shall.
But wasn't it just terrific that Dermot Owen Flood applied, if I want to call myself Scotch Jock, and open Scotch Jock's cheap meat pie shop, I should be perfectly able to do so, shouldn't I?
I think you doing that would be the only exemption a Human Rights Commission would give in this country. As to Hunky Bill, the truth is that the British Columbia Human Rights Commission had an obligation. A complaint was received, and they complied with the law, and Mr. Owen Flood heard the two sides and rendered a decision. Now, what British Columbia Human Rights Commission is going to do is up to them.
Well, they'll probably appeal it at vast expense.
Well, I don't think it'll be vast expense. The truth, though, is that a good number of people were upset by the pejorative hunky bill. The good news, you're full of good news today, the good news is that this is a generational thing, and that most people, your daughter's son and my sons and daughter, wouldn't know what hunky meant. That's the good news.
That's the bad news, too, in a way. I mean, the bad news, because there isn't the same racial distinctions between the new generations that existed in our generation.
Yeah, our generation would understand not hiring a Catholic or a Protestant. Their generation, our children's generation, thank God, wouldn't understand what we were talking about.
That's the good news. Perhaps I'm overcome by the fact, however, that a common sense decision on this, as Dermot Owen Flood said, God bless him, words mean exactly what the speaker intends, nothing more and nothing less.
Yeah, that's Lewis Carroll's Alice in Wonderland, and it's a great quote, and he used it. I used it in a speech in Ottawa. Ottawa, do you remember? That's the capital of Canada.
That's where they originate the mini-series across the country to inspire us with faith, hope, and glory.
Yeah, well, the speeches came out of Ottawa, but there's more to Canada than Ottawa.
Yeah, just on that point, though, a little detail comes to mind. As I recall, one of the groups fighting against Hunky Bill got a $15,000 grant. Was it from you? From the Human Rights Commission to finance their legal fees?
Fortunately, I can survive this hour because we're not in the granting business. The Secretary of State grants under the Multiculturalism Program, and as my understanding, there were some conditions on the grant made to the Ukrainian Association. Now,
Certainly looked like they'd been given the money so they could take their action against dear old Hunky. However, we'll dispose of that for the moment, shall we?
we're pretty good at disposing things.
You never did tell me whether or not you approve of the decision.
I don't approve of the decision and think it should be appealed. I think that we could go back a step, though, and say that it was a mistake to ever have registered that trademark. It's obviously upsetting to a good many people of Ukrainian origin in this country who are entitled to their feelings about a pejorative word, hunky. And why it was ever allowed to be registered is beyond my understanding. Now that it's registered, a decision has been made, and we'll have to, I guess, see what the
That should be
Commission's
appealed,
going to do.
therefore, under the Act, presumably to the, I don't know if that'll be the Federal Court or the Supreme Court of BC?
Well, the Supreme Court in BC. Look, we live by the rule of law, and I don't think that a citizen has the right to use the court for the purposes they think are legitimate. I don't think we should worry about an appeal process. You obviously approve of Mr. Owen Flood's decision. Somebody else doesn't, and we're used to having a court system sort these things out.
Well, now let's take the broader view, and not to be pejorative or anything
Well,
fancy
I'm
like
trying
that.
to take the broader view. That's exactly what I'm
The
here
broader
for.
view is that we become, with our new Charter of Rights and all our litigation, a nation of litigants. Common sense never seems to apply, does it?
A nation of litigants?
Nation of
We're very low in the litigation scale in the world. Our American friends are 10, 20, 100 times in number of actions brought
Except
than we are.
every time something happens in the courts here, I see a parallel or a simultaneous appeal under the Charter of Human Rights. Now, I, of course, have a basic objection to that charter, which I now surrender. The charter is in. We've got to go through that.
I don't understand how you surrender so easily. You're losing your reputation.
Well, because
is
the
in danger.
prospect of changing any part of the Canadian Bill of Rights will take another 57 years, another $57,000.
Yeah, the truth is that a vast majority of the public are very supportive of the Charter of Rights. And this province, by the way, if I can take the offensive for a minute, is a fairly good example of a place where the political rights need to be entrenched, because up until the late 1940s, a good many citizens of this province and of Canada, couldn't vote by reason only of their racial origin. That'll never happen again.
No, that'll
because
never
of the
happen
Charter.
again. It would never have happened again. Anyway, I doubt very much. These gross excesses in anti-civil liberties, reflecting on the Japanese and the Native Indians, have long since been corrected.
They have been corrected, but now they're put aside from any meddling by a majority, either in legislature or the Parliament of Canada.
Could you please explain to me, and I'm sure you'll know it, the big hole in the Charter of Rights related to the notwithstanding clauses? I can't get my eye on it.
Well, the notwithstanding clause is 33, and it allows provinces or the Parliament of Canada to pass laws that may offend the provisions of the Charter, but they have to be reasonable in a free and democratic society. It's up to the government using the notwithstanding route to justify it to the courts.
Every individual is not equal before or under the law until the provinces don't take advantage of notwithstanding.
Well, I'm glad you're not arguing the case in a court on my behalf, Jack. With great respect to you, I'd say that. I'd rather have your son doing it.
Yeah, but the other way around, I should have said that equality rights, as in the Charter, do not become totally embedded for 3 years.
That's right. The equality rights, that's because this province, 9 other provinces, and the Government of Canada have on their statute books a good many laws that offend the principles of this Charter, and they'll have to be amended and reconciled, and it's going to take the governments a fair time to get ready.
He's not Ottawa's Commissioner on Human Rights. He's the Chief Commissioner of the Canadian Human Rights Commission.
That's
Is that right?
it. Thank you very much.
You
That's
so
good.
testify.
Yes, I so testify.
After the break. On the serious side, to the Chief Commissioner of the Canadian Human Rights Commission, how far have you got in your campaign for equal pay in the federal civil service?
Oh, well, it's the law now, and we've had 4 or 5 settlements costing you and other taxpayers $17 or $18 million. But to end a discriminatory practice is worth $17 million.
Can we afford it?
Of course we can afford it. Discrimination, the elimination of discrimination is an affordable social goal.
Now, pilots, airline pilots. Last time round, as I recall, there were a pilot in the East and a pilot in the West who were complaining of mandatory retirement at 60. Did they lose their battle?
They lost the first round, and they're now in the Federal Court of Canada, seeing whether an arbitrary date of 60 should deny somebody an opportunity to continue their profession. We think that that arbitrary, there's nothing magic about 59 and 364 days, suddenly turning 60, and this great professional experience goes down the drain. We'd rather see objective medical testing.
We might finish up with the odd pilot flying his 747 at 85 years of age.
That's the ridiculous upper limit, but a 747 is much easier to fly than any other aircraft in the air today.
I don't have that much faith in that concept. I think surely we're entitled to a cutoff based on the overall probability of a man's health at that particular delicate age after a lifetime of tension.
Yeah, I think that if there are, I'm sure there are objective testing systems that would support a bona fide occupational requirement, but there's that evidence hasn't been before any tribunal yet.
Well, I must disagree with you bluntly on that one. You say that if a guy can pass the test at 60 or 70, not to be ridiculous, and go to 85, he should still be allowed to fly a plane.
That's our stand, yes it is.
The probability of the long, what is it, Thurber used to say, the long claw of the sea puss reaching out to grab a man of 65 is much greater than one of 45.
That's right, and if there's enough evidence, but 60 has become a sort of a magic cutoff date
Oh,
that doesn't make any sense to us.
See, it's just selfishness. I didn't retire at 60. I'm
No,
not going to retire necessarily at 65, but I'm not flying at 747.
Yeah, but look, illness can come on a pilot at 45 or at 61.
Now,
It's
sexual
the
orient-
arbitrariness that
subject
I
I
don't
don't like really to get into, but you have made a fuss in the past, or maybe I'm falsely accusing you again.
No, you don't falsely accuse me very often. I'll set the record straight if I need to.
That's from time to time. Sexual orientation. There's such a fuss going on in this world that sexual orientation must be specifically included from consideration for any job or way of life. Is that part of your human rights campaign?
Our campaign is that people shouldn't be denied employment opportunities for irrelevant reasons. One's sexual preference has nothing to do with the ability to do a job. That's our stand.
It might affect some jobs.
I can't imagine what job would be affected by sexual preference, but
Not
if
about
you
the-
can...
No, seriously speaking,
I am. I'm very serious.
would you suggest that in private hiring of individuals, that even if somebody, how does one put this without being offensive, that in private hiring of individuals, one cannot consider an obvious sexual disturbance about a human being?
An obvious sexual
A
disturbance.
drag queen.
Look, I think there can be bona fide occupational restrictions.
We'll go to that, but in the federal government, is it not a fact that I am very much restricted, perhaps properly, in what aspects of a person's character I may investigate?
Well, of course. The test surely is whether a person can perform the job and not a lot of extraneous private information
I
about
am
somebody.
an old bigot at heart, I suppose.
I don't think you're a bigot, but you do represent a view that's
Common in my age group.
common in your age group, and fortunately becoming increasingly irrelevant.
You mean my age group is becoming
No,
increasingly
not your
irrelevant?
age group, but
mean-
your prejudices are.
And I am increasingly irrelevant.
No, not you.
You're
You're a
accusing me,
lively
Gordon Fairweather, of being over the
interviewer.
hill.
You're a lively interviewer who allows your prejudices to get in the way of your common sense.
What prejudices? I have no
You've just
prejudices. Anything
disclosed
I
them.
say to you is as a provocateur. That's my function in life.
And my function is to keep the record straight about whether things do or don't interfere with equal opportunity.
Your function is to turn Canadians into the race of perfect human beings who see nothing, know nothing, and do nothing.
Let's go on to the next question.
Oh dear, I'm getting in trouble this morning. Equal pay with disabled rights. Well, how much have you cut back your activities and your consultants on the Human Rights Commission in line with the disastrous financial state of the country and restraint?
15% on extracurricular activities. That is, but we're in British Columbia. It might be said that we shouldn't move out of the capital of the country, Ottawa. I take a view that we're a national commission and that we should be seen, intermingle with provincial commissions and travel the country.
But it is
there's
tough
some
to-
extras that we
Do you
don't
find it tougher flying economy since restraint?
I have never flown first class in the 5 years since I took this job, except one overnight flight from Edmonton when I had an important speaking engagement the next day.
Right. Are you prepared to appear as a witness in any appeal that comes by the BC Human Rights Commission or the Ukrainian groups on the Hunky Bill decision?
If I could help the cause of those who think that the Hunky Bill decision is wrong, I'd appear. I don't think they'd want me as a witness. They'd probably think I was biased. I am biased.
Well, there's nothing wrong with being biased.
I know, but you asked whether I'd appear as a witness. I doubt if I'd be called.
You'd be an expert witness.
Well, that's flattery.
Must get you and Dermot Owen Flood together over a pint one night. Let's have a segment of calls to Gordon Fairweather, the Canadian Human Rights, got it right that time, Commissioner, from Ottawa, but not of Ottawa, after the break. You make me feel real guilty, you know. If it wasn't for my ironclad brass neck, you'd make me feel guilty about laughing and joking and cheering Hunky Bill the other day.
It's all right. Everything's all right. I'm fine. I have my pill in my pocket.
Go ahead, please.
Yes, morning, Jack.
Right.
First off, I'm Scottish, so I'll back you just about in everything you say. And, Mr. Commissioner, are you familiar with the Rob Joyce case?
I'm afraid I'm not. Do you want to describe it quickly?
No.
It comes under your sexual orientation.
Rob Joyce was a worker for an agency in Vancouver who got fired after his name had been put on a list, and he claimed he hadn't been properly presented with evidence to support the potential allegations against him, and these allegations have since allegedly been withdrawn. It's a provincial matter. I don't see, but ask a question anyway. It's on a question of an unfair firing because of alleged events related to sexual orientation. Go ahead.
Okay. I was just wondering if you were aware of it.
No,
what you
it's
planned
not.
on doing about it.
Well, I'm not aware of it. As Jack says, it's a provincial matter. I hope that all the questions don't relate to provincial matters.
But it did not attract the detailed attention of the Hunky Dory case, the Hunky Bill case. Go ahead, please.
We have a problem with this interviewer.
Go ahead, please. Where are you?
Yeah.
That's you.
Yeah, I'd just like to know where the Ukrainian people, the province's sense of humor is. Do you, Jack, buy Scotch buy products from Safeway, or?
Yeah, but hunky comes, it flows from the word bohunk and comes from a period in Ukrainian history in this country where the Ukrainian people were very much looked down upon, disparaged. Scottish Canadians never suffered that indignity.
Well, there's still ethnic implications.
No, by and large.
Scotch people are tight with their money.
Oh, mean, cheap,
Yeah.
and drunken.
Yeah.
Yeah.
Yeah. Well, let's go from hunky to Nigger Bill's pancake. Would you think that somebody should authorize that kind of a thing to run a restaurant in British Columbia or anywhere else?
Well, it's a bit extreme, but if they have a sense
Well,
of humor,
that's. I don't think that it's not only extreme, it's offensive and wouldn't be allowed under provincial or federal law.
Under the own flood ruling, if it was a Negro who did it, he'd get away with it.
Well, then I'm glad British Columbia is considering an appeal.
Go ahead, please.
Yes, Jack, good morning. A couple of quick comments for your guest regarding the Airline Pilots Association situation.
Yeah.
First of all, it's strange. I didn't know he was an airline pilot. I don't know what makes him think a 747 is an easy airplane to fly.
An airline pilot informed me of that fact and said they were much easier to fly because of the technological change than earlier aircraft.
Well, that's very true, but on the same token, it's certainly not an easy job, and anybody that...
Well, I didn't say it was an easy job. I said that...
However, you're turning the case around, and you're making it look like you're trying to get rid of pilots at 60. The problem is, I totally agree with you. You shouldn't have an arbitrary age. However, those pilots are members of the association, and they've been a member of the association for many years, and that's what we've agreed on with the company as a retirement age.
Yeah, but an association can't contract out of the law of Canada.
Well,
you can't contract.
Those are working under the association rules that have been decided upon with the company. People in the States, a lot of airline pilots retire when we're 55.
Yeah, and a lot of airline pilots retire when they're 65. They move from a Canadian...
The American pilots lose their transport license at the age of 60. They cannot fly for hire with a large company at 65.
We have evidence that a good many pilots in this country move from the main line airline companies and into other airlines.
That's true, with charter carriers and so on, smaller companies.
So it says that it proves, doesn't it, that 60 is irrelevant to whether a pilot is competent or not. That's all we're trying to say.
That's very true, but these fellows have agreed to work under the conditions of the agreement, and all of a sudden when they hit 59...
Well, it's time the agreement was changed to bring it into line with modern thinking.
Well, that's not what the members voted for. The members voted for that agreement. I mean, why should one person designate what the rest of the members are going to work for?
Well, the members can't decide on something that offends the basic law of the country.
That's the point, but thanks for your call. Go ahead, please.
Yes, I was wondering if your guest was suggesting that the U.S. system or judiciary system was better than Canada because they had 10 times the amount of litigation or whatever.
No, I'm very proud of our Canadian system, and prouder than ever now that we have a Charter of Rights and Freedoms entrenched.
Okay, do you not agree that it seems that we're leaning towards the U.S. system and that as a result we will have much more litigation and basically just tend to employ more lawyers and that people will be scared to even comment without having someone like yourself and your commission jumping down their backs every time they try to do something in this country?
I don't think there'll be much jumping down anybody's back from me. I'm a libertarian and have been. I've had a parliamentary career of 25 years. Obviously a supporter of free speech. It's entrenched in the Charter. There may be, in fact, a little more litigation because there are provisions, legal rights provisions in the Charter that will allow more testing of procedures that are in place now. But that doesn't say we're necessarily becoming like the Americans.
Question from me. Recently, we've just cut back $1.3 million from our legal aid program in British Columbia, and we've established arbitrary limits of income and above which you are not allowed to get legal aid. Is that a breach of the Charter of Rights on the face of it?
No, that is a decision presumably of a duly elected legislative assembly, and I would think would fall within Section 1 of the Charter, being reasonable. It might be that if the decision was tested, it would be up to the government to prove that it was a reasonable decision.
This is where the Charter of Rights, for the moment, worries me. We had a union out here complaining that the provincial government had no right whatsoever to make any cutbacks because hospital service is protected by the Charter of Rights.
But who won?
They lost.
They lost.
Yeah.
Well, that's demonstrably reasonable in a free and democratic society.
I don't suppose
They
the
lost.
expense doesn't matter, or the time, or the blocking of the courts.
Well, the courts are there to try to adjudicate, and in the case you explained to us, they made a decision.
And for once, a decision with which I agreed. Next call. Go ahead, please.
Mr. Webster.
Yes.
I wonder how your guest there can use the words free speech and proud of our court system, et cetera, when this poor man, Hunky Bill, had to spend over $300,000 of his own money in order to keep his own name on his own business.
Well,
I think as a taxpayer, Mr. Hunky Bill, who probably pays a great deal of taxes into British Columbia, has the right to call his business whatever he wishes to call it.
Well,
I
so
think the $17 million or so, whichever is afforded this gentleman for his business in the East, should be put in to our justice system all over Canada instead of cutting back for people like us taxpayers having to go to court. These people are given grants to be able to go to court to
okay, you made your point. Yeah, you made your point, my dear.
Name taken off his business.
The Ukrainian groups denied that they used the $15,000 to prepare the lawsuit.
I believe, sir, that is a lie.
Well, I don't know it, and I've got to give their side of the story. It seemed ludicrous to me, too.
Can I also make one other point?
Yes, ma'am.
It might be that the United States is using 20 times more suits in their courts, but maybe it's because there's 20 times more people there.
Thank you, ma'am. Stay for another segment this morning, please, Mr. Canadian Commissioner of the Human Rights Doohickey from Ottawa.
be delighted.
After the break. Gordon Fairweather, Commissioner, Chief Commissioner for the Human Rights Commission, Canada, from Ottawa. Go
Great
ahead.
title, isn't it?
Yeah, it's clumsy. Yeah. From Chemainus. Go ahead, please.
Hello.
That's you.
Good morning, Jack.
Mm-hmm.
And Mr. Fairweather.
Good morning.
I have one question, then I'll hang up. My parents were European-born. I was Canadian-born. Under the new Charter of Rights, am I allowed to call myself a Canadian now?
You're Canadian-born and your parents are Canadian citizens, of course. Call yourself a Canadian. Why not? It's the Canadian Charter.
Funny, isn't it?
Yeah.
That's a odd question. Go ahead, please. Maybe harking back to the good old days of early censuses when they used to ask for racial origin many years ago.
Yeah.
Go ahead, please.
Hello.
That's you.
Yeah, Mr. Webster.
Yes.
Yes, I heard the comments this morning regarding the Hunky Bill decision, and I wish to state that I am totally in favor of Mr. Fairweather's opinions, and I do think that there was a gross injustice done to the Canadian people as a whole by having the trademark registered in the first place, giving this person the feeling that he has a prior right to the use of a word, regardless of whether it is affable to one person or considered to be a discriminatory and a derogatory and a very degrading word to other people.
Well, were you part of the action against Hunky?
Pardon?
Were you part of the action against Hunky Bill?
No.
Thanks for your opinion, and you've put it very well.
Thank you. Go ahead, please.
Good morning, Jack.
Morning.
Yeah, I'm from Scotland too. I'm from Govan. And in regards to Hunky Bill, wouldn't it be legal if Hunky lost his case in regards to not using that name? Would it be legal for him to change his name to Hunky Bill Koenig and use it that way? I don't think they could do anything about it if that was his real legal name, would it?
Well,
Hang up
Hunky...
and listen.
Oh, I see. He wants to use the courts
suggested-
for a change of name. Instead of Gordon Fairweather, I'd be Hunky Fairweather. Is that what you have in mind?
That's what he has in mind.
Yeah, well, I would think that a judge would know that that's a pejorative and wouldn't allow such a thing. Judges are entitled to use discretion in name changes. I might have a nickname, of course, that isn't part of the judicial process, but you couldn't have a name change including a pejorative word like that, any more than I could be nigger Fairweather or chink Fairweather. They're pejorative, offensive words and hurt fellow Canadians. That's why there's a fuss about this.
Well, what about reducing this to sanity and me giving you a proper nickname?
I've had many nicknames in my political life, and
how about the old Silver Fox Fairweather?
I've never been referred to that except when I get across the mountains.
Yeah, but that's not that. You wouldn't object to being called the old Silver Fox, would you?
I wouldn't object to any adjectives that you might use.
Go ahead, please.
I'm a little upset about the old. I'm getting old, but I'm not old.
Well, I mean, it's your hair that makes you look older than me.
That's true. That's true. We all.
I use clear oil.
Anyway,
just tip the edges. Go ahead, please.
Hello?
Yes, ma'am.
I would be nervous flying with someone over 60. Aren't there more heart attacks, strokes in men over 60?
No, the medical tests have not proved that this to be the case. The pilots would be subjected, as they are now actually, to very stringent medical requirements. The Commission's view is that this arbitrary date, that a pilot can have an attack of this kind at 40 or at 50 or at 65, and it's the arbitrariness that bothers us. The same very stringent medical requirements would go on as they do. We're not in the business, obviously. It would be madness on our part to hazard public safety.
Except, you know, I know you're right, I know you're logical, I know everything you say is correct, but your reaction time at 60 has got to be slower than your reaction time at 35.
If the reaction time is shown by medical tests to be longer and therefore endangering public safety, that's a bona fide reason to dismiss that pilot.
Go ahead, please.
Yes.
Yes.
My question is for Mr. Fairweather on age discrimination.
Right.
Is it correct that it is illegal for an employer to request your date of birth or age on an application for employment?
Age has nothing to do with one's ability to do the job.
I'm talking about whether it's legal for a prospective employer to ask for your date of birth on an application for employment.
Look, you've caught me with my facts down.
Well, let's say in the Federal Civil Service then.
Yeah. I, on the face of it, think that's a legitimate question, as long as the age doesn't inhibit the employing process in any way.
Well, of course
I mean,
it
they
does.
may need it for statistical reasons.
No.
But not for reasons of saying yes or no to a job.
Well, if you don't have to give your age, but you do have to give your social insurance number.
The social insurance number is used for identification purposes.
It also identifies your date of birth.
It identifies your date of birth?
Yes, it's coded for that.
Yeah. Well, you don't have to put your social insurance number on many application forms.
If a man came to me and wanted a job and wouldn't give me either his social insurance number or his date of birth, I'd say, get the hell out of here.
I see. What? And
wouldn't you?
I wouldn't have the slightest interest in somebody's social insurance. It would be meaningless to me.
Well, I'll tell you one reason I want to know if he was legally in the country. That's the first thing. If he hasn't.
Well, there are other ways to find that out.
I can't think of one offhand. I mean, for me, as an outsider.
Yeah. You
Can I
think
ask
that people trotting in here to BCTV, very many of them are in this country illegally? We have a very efficient police system, a very efficient immigration system.
I disagree with you entirely on both
Do
counts
you?
as far as
All
that's
right,
concerned, and I would say, yes, it's possible that people would come in here without a social insurance number, and I would say, not legal.
Yeah, well, I want to return to the questioner. It's when age is used, wrongly used, to deny an employment opportunity that human rights commissions are bothered by it. I frankly can't answer whether it's legal or not legal to put it on. I can't imagine why one would need it. Nobody asked me how old I was when I ran for Parliament or was asked to undertake this job.
You had to certify that you were over the age of 21.
When I
ran for Parliament.
A long while ago, that's true.
That's that you were on the voters list to be eligible to run for Member of Parliament.
Yeah.
Well,
okay, thank you.
Okay, thank you. That's a great call, and it's our last one. I'm just going to finish with a request to the Commissioner. The question from the caller is it illegal for an employer to ask for date of birth or proof of date of birth from a job applicant? Could you give me the answer so I can tell my audience?
It is not illegal to have that information, but it must not be used as a barrier for the next process in hiring or firing.
Now,
it has nothing to do with whether somebody can or can't do a
but you're
job.
now saying that I, as an applicant, must answer my age and prove my date of birth. If my
Look,
employer
I
asks
was very frank with you earlier. I am unable to specifically answer whether it's legal or illegal in the lawyer's sense of the term. If age is used to deny me a job, then it's the wrong question to
I
ask.
agree on that, but it was just a little nitty-gritty question. Must I answer?
But I took the listener's question as being very seriously proposed, as yours was.
Yes.
And it isn't beyond the realms of possibility that even a person with a fancy title like mine hasn't the answer to every
no,
question.
I'm not blaming you for not
That's
having the
all.
answer, sir. I'm merely asking if you'll give me the answer in due course.
I'll call you in 10 minutes and give you the answer. My quick answer is it is not illegal.
Well, that was a good spirited section this morning, Gordon.
I look forward to a
You
spirited
embarrassed me greatly on at least one occasion, and I apologize to you fulsomely on another occasion.
And I apologize.
Fairweather, chairman of the Canadian Human Rights Commission, winner of this contest by a knockout. I'll be back after the break. Rentalsman's problems used to be, it seems to me, problems of affluence. Now the pendulum may be swinging in another direction. And quite simply, I have Jim Patterson, BC's rentalsman, here this morning to bring me up to date on vacancy rates, problems, the downward trend, if there is any, in rents, etc., etc., etc. I was fascinated when I was driving back and forward through Surrey the other day to see notices, and on the Lougheed Highway, rents insured against unemployment. Does this indicate that there is a massive vacancy rate and that landlords are suffering?
Well, it indicates that vacancy rates are going up. Landlords are having a very difficult time with renting some of the newer buildings. So we've seen come onto the market all kinds of gimmicks. The common ones are maybe rent reductions or 1 month's free rent and some financial incentive. But we're also seeing more creative ones, free trips, we'll pay your moving expenses. One in the summer had free windsurfing lessons if you'd move into their place. And this is one of the more recent ones, and we've looked at it, and it appears to be bona fide that they are, in fact, insuring against layoffs.
Now, you pay a premium, and they insure you for X months against loss of employment and inability to pay your rent.
Well, it's incorporated into the rent, but in fact, yes, it's somehow built into the rent. But the rents are competitive, so for many people that have some uncertainty in their profession, that's going to be an attraction.
The Renting Housing Council says that Greater Vancouver now has 3,000 units vacant. Does that meld with your figures or CMHC figures?
Well, the official CMHC figures are not yet out, but they will be in the next week or two. However, we've got a pretty good idea what the vacancy rate will be, just looking at what's happened this year. And for one thing, BC has not seen a growth in population, and that's the first time in quite some number of years. We've actually seen a decline in the first 6 months. About 1,300 people left in the first 6 months of this year. That's compared to about 11,000 moving in the first 6 months of last year.
Oh.
So the change has certainly had an effect. When you combine that with 1981 being a record year for rental housing starts, you now have all of those units coming onto the market and nobody moving in to take them.
About a quarter of them must be standing empty.
Well, the vacancy rate, in fact, we think is still under 2%, the official vacancy rate. But when you add on the new buildings, that clearly will start going up. And that still does not sound like a very large vacancy rate. But the last time in British Columbia, in the Lower Mainland, the vacancy rate exceeded 2% was about 10 years ago. So we're probably at about a 5-year high already and increasing.
Have you noticed any big increase in the number of applications for evictions for non-payment?
Yes, related to the recession. What is happening is, as unemployment goes up, there are more tenants going into rent arrears and therefore more applications being made. Although with the higher vacancy rates, in some cases, landlords are carrying the tenants further. In general, we're seeing less disputes over evictions. Landlords, when they have a waiting list, can afford to be much more particular with a tenant than when they don't have a waiting list. So people are being a little more reasonable and negotiating
How about the rents? Have they gone down at all? I mean, the rent's noticeably gone down?
Well, in the higher renting units, we've seen some actual rent reductions. Overall, rents are still going up. In fact, overall, rents are still going up faster than the rate of inflation. But they are on their way down. That is, the amount of rent increase is on its way down.
Just before we go to phones or anything, Jimmy, would you give me, for the sake of a refresher course, the rent control limits in BC as of this moment?
Okay. 1-bedroom units renting for $300 a month or less, 2 bedrooms for $350 a month or less, and 3 bedrooms for $400 a month or less are subject to a 10% rent increase limit.
10%. And once they go over that limit on the natural 10%, they come out of controls.
Yes, and most are now out. Over 60% of the market is now over those limits and out of controls. And when you look at the vacancy rate being around 2%, that's a little bit misleading because what you really have is a near zero vacancy rate in the controlled units. Those are next to impossible to get. And a higher vacancy rate, probably closer to 4%, in those that are out of rent controls, and indeed vacancy rates of 20 and 25% in some of the new projects.
Well, now that you've nearly everything's out of control, 60%, you've cut your staff by the same amount.
Well, unfortunately, it doesn't translate to a reduction in workload to us. As long as the rent is not over $700 a month, tenants can appeal on an individual basis. Now, those appeals are not based on any magic number or formula, just a comparison with the market. So if an individual landlord tried to gouge a tenant and evict them, say, through a large rent increase, we could step in. So we're still getting a number of those appeals.
Yeah, so you're still as busy as ever. Okay, I'm going to go straight to telephone calls now with Jimmy Patterson, the rentalsman, after the break. Jim Patterson has moved his office for the moment as rentalsman out here so he can answer your questions. Kelowna, go ahead, please.
Hello?
Yes, from Kelowna.
Yes, Jack. Good morning.
Morning.
Good morning to the rentalsman.
Morning.
I would like to know, about the discrimination against children in condominiums.
Okay.
And how they can do that.
Well, all right. A landlord is permitted under the legislation to make restrictions on who he enters into a tenancy agreement with. And it is permissible in Canada to restrict on the basis of children and pets. It's a fairly controversial issue, but at the moment, a landlord's, I guess, approach on it is some buildings were not designed for family orientation. Some tenants do not want to live in a building where there are children. And in other situations, they were designed and attract tenants with children.
So it's legal?
Yes, it is legal to do the restriction. The problem is that there is a shortage in a very tight rental market of landlords that will allow children, and therefore it becomes a problem. As the market eases somewhat, we're seeing more landlords willing to accept children,
and
I
take
think
pets.
yes, and I think that's an improvement.
Go ahead from Williams Lake.
Williams Lake, one question. I paid rent for 1 year. I'm a senior citizen on my apartment. I won't mention where it is, I might get evicted, but I have had no service.
What do you mean?
All I would like to know is, how do I go about getting my stove, etc., fixed? End of quote.
Okay, a landlord has an obligation to provide reasonable maintenance, and that includes appliances. So the first step is to go to the landlord and attempt to resolve it that way. Assuming you've done that, then the next step is to contact one of our offices. You could contact the Kamloops office, and we would then contact the landlord, explain the legislation, and if necessary, we could redirect the rent and ourselves arrange for the repair of the appliance. And on some occasions we have to do that, and we have to actually seize monies and make the repairs or the replacements. But in most cases we can do it through negotiation.
Have you spoken to the landlord?
I have many times, and all I get is a bunch of gobbledygook.
Well, you better go to the rentalsman in Williams Lake in Kamloops. Can you do that?
Roger. Thank you very much.
Okay, bye. Go ahead, please.
Yes, Jack. I'd like to make a case to the rentalsman where I had a tenant that rented a suite for me, and prior to them leaving, they damaged a fridge I had. I was advised by the rentalsman's office that in order to substantiate my claim against them, which they appealed, I would have to get an appraisal from a repair company saying that the fridge was damaged, which I paid $24 to obtain. And we brought this case to the rentalsman's office, to the appeal process. The rentalsman, in turn, found in favor of me, but in the process, the repairs cost in excess of the value of the fridge. Now, what happened in this respect was I had an invoice from the repair people showing how much the fridge would cost to repair. I asked them what the value of the fridge was, and they told me, and I wrote this down in my own handwriting on the invoice.
Mm-hmm.
When the rentalsman found in my favor, he said, yes, they damaged the fridge. However, in his opinion, the fridge wasn't worth what the repair people told me it was worth, and he decreased the value of the fridge. I found this rather strange, that he found I was right, and yet he, in his opinion, was able to put a value on a fridge.
He was cutting the baby in half.
Beg your pardon?
He was cutting the baby in half.
Well, correct. I don't know if this is within his jurisdiction that he is not only can solve an appeal, but he also is an appraiser.
Well, okay, what the officer has to do is to determine what is a reasonable claim. Without knowing the case, it's difficult to comment on the specifics, in that normally the appraisal or estimate to do repairs is is permitted. That is the normal practice, is whatever it costs to repair the damage is what is allowed. But there can be all kinds of other circumstances as to how old the appliance was. Possibly some of the problem was caused through normal deterioration, which you would be responsible for.
So the figure that was provided was not one that I plucked out of thin air. It was one that was provided by the repair company.
Well, it was within the power of the rentalsman's officer, was it?
Yeah, now I would have to know the balance of the case, because the normal procedure would be you would allotted the full amount.
This is going on forever. How much money did you lose on that one?
$50. It cost me. I had to pay $24 for the repair and the.
That's enough. Thank you very much. Go on forever. Go ahead, please.
Good morning.
Morning.
May I speak to Mr. Patterson?
Yeah.
Mr. Patterson, I applied last year for about 10% rent increase because I'm under rent control. That was in November last year. And an additional 10% because my taxes went up 30%, cable vision 20%, garbage pickup 12%, natural gas for heating and hot water 24%. Second mortgage went from 12 to 17%. And I haven't heard anything from your office because I haven't got an answer. And now very soon I have to give him another increase for next March again. What can I do about it?
Well, okay. That is a valid problem and a fairly common one. What happened over the last year is with the higher interest rates and so many landlords refinancing at higher interest rates, we were literally inundated with applications. Over a few month period, the number of applications from landlords literally tripled. And that created a backlog because, of course, we're under the same restraint guidelines that other public servants are under. And we have actually been reducing our staff, not increasing it. And while reducing the staff, we're attempting to cope with this very large increase. And it's taken some effort. It is improving, and the backlog now is going down. So if you have found that it's taken some number of months, you should be in touch with our office to find out where it is. But all I can say is that's a valid problem. I apologize, but we are limited by the number of staff we have, and it's been a very serious problem for so many landlords.
Yeah, but the problem is every time they want to prove that this and this went up that much, I bring it down to your office. 2 months later, I get another letter I have to bring up for the second mortgage again, so I bring that up. And every time there's something else coming up, I mean, I don't go ahead with the whole thing, you know?
Maybe stop bringing us things and let us make the decision. One of the problems we have is every time you bring us something, because we're acting like a court, we have to let your tenants know, give them a chance to comment, so that actually slows down the process. If you can justify a rent increase of 20%, then you will get it, and we would consider any delays in making that decision. So if it took 6 months to have that resolved and you'd been carrying some additional costs, that would be reflected in the decision that's ultimately made.
Yeah, but what do I do normally, a new increase what I have to give him by the end of this month? According to the old rent plus 10%, or how do I do it now?
Well, give an increase for the resulting rent that you want to charge. So the final rent is the amount that you want to charge.
And shouldn't they go down and harass your people, though, the guy? Maybe. How many suites have you got?
20.
20. Sounds like a reasonable guy who's been waiting for 6 months?
12 months.
12 months? Jimmy.
12 months sounds long. I assume because there has been additional evidence. We were running at averaging about 6 months on those applications. That's now down to about 4 for those applications that are coming in. Should be down to about 3 by year end.
I mean, I can give you the officer's name if you want to.
Well, no, but come down or call that officer and find out what is happening. And if you're not satisfied with that, write in to me and I'll pursue it.
Tell the officer that Jimmy Patterson told you to call him today and can't understand why it would take a year and that something's wrong.
Okay then.
Okay. How's that?
Good.
After the break. Jim Patterson is a rentalsman. He's been there a lifetime now. How long?
4.5 years as rentalsman and about 3 years prior to that managing rent controls.
Are you buying? You don't rent?
Actually, I do right now. I sold my house about 6 months ago, and I am now a tenant.
Right.
So I was once a landlord, and then a homeowner, and now a tenant, and tried them all.
If you've got any complaints, make it to the Rentalsman.
Yeah.
Rentals person. This is arrant discrimination. Rentals man. You're not a man, you're a person.
That's right.
It's the Rentals Person Act. Isn't it stupid? Go ahead, please. To the Rentals person.
Good morning, Jack.
Morning.
Jim. I'd like to know exactly when people are going to stop the rent increases or slow them down here. Every year they've been going up 10, 15%. They keep going at this rate, we're going to be paying a couple $1,000 a month for rent here pretty soon. Keep things up. And like on a lot of these rent increases, one landlord was just talking about they raise his garbage up 10% and his power so much. And the thing is on these big complexes, like I'm living in a big complex out here in Surrey where there's 300 apartments in the complex. So say they pay $1,000 a year for a garbage pickup, and they raise the garbage 20%. Well, 20% of $1,000 is $200, so it'd be $1,200. But then they go to you and they want a 10% increase on the rent of 300 apartments that are paying $300.
Good point, but the answer is quite simple from the Rentalsman.
Well, actually, it's not that simple. This is probably the core of the controversy at the moment. There, in fact, is a fairly large lobby from tenants that is growing to restrict rents to the 6 and 5 in line with some of the federal restraint guidelines. However, the restraint guidelines, both federally and provincially, have specifically excluded any private sector wage or price controls. And the problem is that landlords' costs are not controlled and are going up by large amounts in some cases, and particularly in the case of a refinancing of a mortgage. So to control the prices in isolation of the costs is probably not feasible. But then the argument goes beyond that, whereby landlords are certainly arguing that the market should determine rents, as used to be done prior to the inception of rent controls. And there are some problems with long-term rent controls that we're now seeing. So there is also a lobby coming from landlords that say, never mind even looking at costs, there shouldn't be any controls, there shouldn't be any review, and that is being argued at the same time. So the controversy is growing.
What about the other side of the coin, though? Guys who were paying 17% last year, if they got out of that, might only be paying 13.75 now. Has any landlord doesn't have to come to you to reduce his rents, does he?
No, and that also is an argument that tenants are putting forward.
Good one.
Well, I guess the issue becomes one of, is the government going to establish and set rents through formulas rather than the marketplaces? And if that's to be done indefinitely, then yes. But that has some other long-term implications.
But the simple point is that the policy of this government is to have certain rents under rent control and 10% increases allowed.
Yes, and I think the policy is to phase out of rent controls and have rent review available for appeals, but not set rents through formulas.
Go ahead, please.
Yes, Mr. Patterson, I was just going to bring up about the 6%. I thought you should follow the provincial guidelines. However, you've just explained that. An officer in your department told me she could not consider anything under 10%. Is that correct?
Not precisely. We could consider something under 10% on a rent review. What you're referring to, of course, is where the landlord gives a 25% rent increase. That's and right. The tenant proposes a 5% rent increase or a 15% rent increase.
Yeah.
The problem if you propose less than 10 is that the landlord was in the situation whereby he or she would have been better off under rent controls. And that was not the intention of rent review, to be more restrictive than rent controls. So I would advise tenants, if you're appealing your rent, to keep in mind, firstly, that inflation is running near to 10%, and secondly, that landlords could have obtained 10% under controls, and it might be a better strategy to propose something a little over 10%.
Well, don't you think it would be fair to the tenants to let them know that they don't have any opportunity at all if they don't propose at least 10%?
We do, and many tenants inquire as to what they might do, or they inquire from tenant associations what they might do. But legally, we can consider something under 10%. We have, It would be inaccurate to say that we cannot, because there have been occasions where landlords have been exceedingly high and costs have gone down and mortgages have gone down, and in that case there have been some situations where we've allowed less than 10. But I would think that you would normally think in terms of that's less than the rate of inflation and that's less than a landlord can get from controls, and what we're doing is looking at what is reasonable.
Okay, ma'am, thank you. Have you ever turned a landlord down?
Oh, yes, yes.
Flat, nothing?
Yes.
Go ahead, please. How about security deposits? No problems?
Not in this marketplace.
Hello, Jack.
Go ahead, please.
Yeah, it's Mr. Patterson.
Yes.
Are all your documents in your office binding?
You mean our orders?
Okay, I rented a townhouse, eh?
Mm-hmm.
And I came down to your office, and can I mention the company that I dealt with?
Can if you like. No, you better not. Never mind.
Cap Realty is now Van Realty. I came to an agreement with them in your office that I owed them X number of dollars, eh?
Well, if you're going to use their name, tell us how many dollars you owe them.
Well, Jack, I don't have the thing here in front of me.
What's the point?
Okay, they came back and they turned around and said, well, after they signed an agreement, I signed an agreement, the rentalman signed an agreement in your office. Then they came back and said I owed them $400 and some odd. Now, is this right?
No,
well, if we made a decision and made an order, a finding, then that order is as enforceable as an order from the small claims court. We would operate identically to small claims court. But that wouldn't necessarily prevent the landlord from coming with a further claim, which may be the case. But if an order was made, then yes, it's binding.
Well, you can have the parties in and they'll all agree and sign a deed, and if you put your stamp on it, it's a legal document.
Yes, if we rule and say, yes, this is the amount that will be awarded.
Go ahead, please.
Yes, is that for me?
That's you.
Okay, I'd like to speak to Mr.
He's
Patterson.
here. Go ahead.
I'm not ignoring you. I would like to find out, you know, if they can change the Cablevision in your name after you've been living here for a while.
Well,
what
okay.
does that mean?
What they're doing is many buildings are switching from bulk Cablevision to individual Cablevision, and at which time the tenants are paying for their own Cablevision. And
is that one way of getting out to make it a little bit cheaper for them on their part?
Well, a lot of it is being forced by the Cablevision companies. There's a number of reasons why they want people to go to individual. The signal's better for some of the future plans of Cablevision companies.
Jerry,
just a minute.
don't
Who's?
forget that he owns 5 or 9 buildings, and
Is that?
he went and
Just a minute. Just a minute. I want to get the. Is that the old lady picking up the other phone?
And he went and changed it, so each suite is separate. Don't forget
that's
no,
what
no,
we
I
understand.
No,
Yeah,
I
we
understand. I
understand
understand. Yes, I understand what the issue is. The answer is this is happening, and it's common, and it will continue to happen. I would think that in a short period of time, bulk Cablevision will be discontinued by most Cablevision companies. And yes, a landlord can transfer to individual payments and individual hookups. Now, there may be an argument to reduce the rent if you're under rent control. And if you are under rent control, then you should be contacting our office, and we will look at it. It would depend on individual situations, and you may end up with a rent reduction. If you're not under rent control, then it would be like a rent increase.
Okay.
Can I speak further on this matter, because I'm a former manager.
Right.
See, we had trouble with children in the building where I was managing at one time because of paper and gum on the floors and stuff like this. Well, this is the only competition that the owner has to offer right now, because they got to compete against these newer buildings going up. And New Westminster, where I live at right now, there's lots of kids, and you know, they literally dirty themselves in the hall and
What's
cause
that
the
got
manager a lot of more problems.
What's that got to do with Cablevision?
Well, that's just another...
Oh, I realize
thing,
that. Let me ask
point
a
of-
question here, though, Jimmy. If I get my Cablevision changed from bulk to individual, and I'm a tenant, I don't have to take it, do I?
No, that's right.
I would
but-
have to sign a new contract with the Cablevision company at the individual rate, wouldn't I?
Yes, but where the concern is those that do use Cablevision are now going to be billed directly by the Cablevision company, whereas it was included in their rent before.
It's a rent increase in effect.
Yes, and therefore one should contact our office to see what the situation will be in their particular circumstances.
If you deal with all these little nitty-gritty things, God, what a bulk of detail your people have to deal with.
Well, that's one of the reasons we're trying to get out of some of the minor issues. For a period of time, we were inundated with complaints about laundry charges going from 50 to 60 cents. And it's probably not reasonable to be down trying to control at that level when we're really moving towards market rents anyway. And fortunately, the market is improving enough that we're finding it's going into equilibrium and people are striking their own deal without us being involved.
Okay, more with Jimmy Patterson, the rentals person. I will not say rentals man. It's discriminatory and against the Human Rights Code. Rentals person after the break. Just before I go back to rentals person, I've got 5 impassioned telegrams from certain groups in the province of British Columbia to which I better in all fairness give a nod. The first one I got was from Dear Jack. The 20,000 supporters of pro-life in BC say Morgan Taller is manipulating the media. Stop Webster from his blatant support of abortion on demand. This will lead to an abortion free-for-all. Money is the object, not women's rights. Why Morgan Taller, not Nathanson on Webster's show? Came from the Provincial Pro-Life Society of BC. Unfair bias I'm accused of. And another one, which came from the Vernon Pro-Life Society from Margaret Maguson. And it says, Dear Jack, we were disappointed in the biased approach by you when you interviewed Morgan Taller. It is most discouraging that the lives of the unborn are shown so little concern. Do you plan to present the other side of the issue? Margaret Maguson. Well, it appears that last year I had Nathanson scheduled for my program, but due to some set of circumstances which were fully justifiable, or I can't remember, I cancelled Nathanson out. So tomorrow morning, like it or lump it, you're going to have 2 people from the Pro-Life Society of BC on. They got to have their fair say. You must defend to the death the rights of those people who say things you don't agree with. So they'll be on tomorrow morning. However, back to Jimmy and Abbotsford. Go ahead from Abbotsford.
Hi. We just moved out of our apartment in the beginning of October, and we just got a letter from our old landlord saying that they're keeping our damage deposit and charging us additional. I don't have the letter in front of me. My husband took it to work with them. They're keeping $50 for because they say that we didn't give them enough notice. We gave them our notice when we handed in our rent, which was on the 1st of September. And I can't figure out why they're keeping it, because we were renting on a month-to-month basis, and we moved out at the end of September.
Okay, because you're required to give notice that you're leaving 1 day before the beginning of the next month. So you must give notice on the last day of the previous month. And the reason for that is that is when most tenants give notice, and even that 1 day late means that a great many other landlords will have a 1 day jump in advertising for tenants and in obtaining them. And by time that landlord advertises, many of the incoming tenants will already have found places. So to make it consistent, the legislation requires a notice to be given at least by the end of the month. However, the landlord has an obligation to try to re-rent. So that only applies if the landlord...
Well, he did re-rent. He rented by the middle of the month because there was people coming through our apartment all the time.
But for the first of the following month?
Yeah.
Then you would have a claim, because the law says that the landlord must try, and if the landlord fails, then the landlord would have a claim against you for any revenue that might be lost. But
No,
if
he
the landlord
rented.
was
He's also
successful, then they couldn't retain that, and in that case you should come to our office.
Yeah, he rented it, and he's also charging us for the advertising, for $61.50 for advertising.
Was the apartment empty after you left?
No, it was empty. We moved out on the 24th
And?
because we had another place that we had to get into.
Mm-hmm.
But it wasn't empty on the first when we were out.
So, if somebody moved in, then you have a claim.
And
Now, the landlord's going to argue that there was additional costs, potentially. That might be the advertising. The landlord might say, well, because I was late, I had to take out more ads, and we will listen to that argument and yours. But if there wasn't a rent loss, then you certainly are entitled to get that claim back, it would appear, based on what you're saying. So it sounds like the kind of dispute that we might have to hear. First, go to your landlord before you bring it to us and explain that. Say you were talking to me, and attempt to resolve it between you. If that fails, call our office, and we may be able to resolve it over the phone. But in the worst case, if it comes down to a dispute that can't be resolved, then we act just like small claims court, and we'll hear it and
give a
determine.
decision. Thank you, ma'am. Best of luck. Go ahead, please.
Good morning, gentlemen. I am a landlord, and we had one tenant gave us notice a week yesterday that they were moving out on Saturday, which they did. Of course, they lost their half-month deposit, but they left the suite dirty, and they did not leave the keys.
Okay, what can she do? We've only got 30 seconds.
I don't know what to do.
Okay, here's the answer from the rentalsman.
Well, you can claim for any additional losses. If you lose some additional rent, you can claim for that. If there's unreasonable cleaning that has to be done, that is beyond the normal preparation, you can claim for that. You can claim for any damages. You can claim to have the locks changed and so on. Now, the practical problem is you've got to find them to be able to execute that claim, but you have a legal claim against them.
But it's another claim which she should make now in person or by phone at the rentalsman's office.
No, in that kind of a case where you've got a number of clear losses, you want to come down to us, file a claim on the tenant, and proceed.
My thanks to Jim Patterson, BC's rentals person. And I'll be back after the break.